This morning's docket, case number 106288, State of Kansas v. Jimmy Dominguez.
Good morning. Mr. Dominguez appears to counsel Michelle Davis, and I'd like to request 2 minutes for rebuttal, please.
2 minutes is granted.
I think that the issue I'd like to focus on is issue 1 in the brief, and that's regarding the court's instructions to the jury on the charge of first-degree murder. In this case, the state had charged first-degree murder, either premeditated murder or felony murder in the alternative. And then the state had also charged, there was a second individual who was shot, and the state had charged either attempted murder or aggravated battery in the alternative. The allegations here are that Mr. Dominguez had shot, as the garage door was opening, he had shot an individual by the name of Leyva, and then another individual was also wounded. And so I think as our brief and the state's brief set out, the problem with the court's instructions in this case is that it presented, which is good, that it presented premeditated murder as an alternative to premeditated murder. It did so in a way that said premeditated murder is first-degree murder, and then we have this alternative charge of felony murder. But the court did not indicate to the jury that that felony murder is also first-degree murder. So that's one problem. And then the second problem with the court's instructions is that it didn't tell the jury then when to consider felony murder. It told the jury that when you consider premeditated murder, if you do not agree on that, then you consider second degree. But it didn't really tell the jury how felony murder, when to consider felony murder. So those are the two problems with the court's instructions. So I think our contention in our brief is that because of those errors, that the jury was not told to deliberate premeditated murder and felony murder at the same time.
Did the prosecutor cure it when the prosecutor explained what to do in closing argument?
The prosecutor's statement in closing argument was an accurate statement of the law, telling the jury that felony murder and premeditated murder are both types of first-degree murder. That's true. You would then have to assume that all of the jurors listened to that particular piece of the argument, and that the jurors understood it, and that they remembered what the prosecutor was saying, and they were able to use that in the jury room, despite the fact that they had instructions in the jury room that told them something different.
Can a prosecutor cure the inappropriate statement of the law by the judge who says, I'm going to give you the law?
That is the problem. That is the problem here.
And the verdict
Even
form.
if we assume they heard it and understood
and
it,
they
can it
understood
really
it, and they remembered it, and then they used it to somehow clear
overrule
any
the judge's statement of the law?
right, and to clear any confusion that they would have. That
The
would be,
verdict form was incorrect too when they went to write. Didn't the verdict form have the sequence first, second, and felony?
that's right. It was
At least indicating that was the sequence of.
right, and that was discussed at the instructions conference. The judge actually had first-degree premeditated murder, then second-degree, then felony murder, and the prosecutor said, I think we should switch those. So they put felony murder second, they put second-degree third, and then not guilty. And then in the last one is
So it was correct in the verdict form?
no, because the standard verdict form they're both together. Premeditated and felony are together. And in this verdict form, felony was after premeditated first-degree murder.
Let me clarify your argument based on my colleague's questions. Are you saying the court did make a misstatement? I thought it was more that the court just didn't make a statement that was necessary to be beneficial. Are you saying there's a statement that is inaccurate in the instructions?
Yes, the instructions misstate the law.
By not ordering them?
By not telling the jury that felony murder is first-degree murder.
That's an omission, not an affirmative statement.
Well, when you tell the jury that premeditated murder is first-degree murder, and you don't tell them that felony murder is first-degree murder, I mean, it's an omission, but it's not accurate. So, and then when you don't tell the jury that to give them equal significance or weight while you're deliberating, because when I was reading back over this and I read back through the instructions again, I think it just leaves the jury with the impression that those aren't equal in stature and significance.
I don't disagree that these instructions were a mess.
Okay.
So I'm not going there. I'm just trying to make sure I understand that you're not saying that the judge made an affirmative misstatement. It was just error by omission, in essence, by not really explaining the law for the jury to apply. And I don't know if that makes a difference. I just want to make sure I understand.
Yeah, I think I can agree with that.
On both the instructions and the verdict form. Sin of omission rather
Well,
than
no,
commission.
I mean, that's what's my hesitation is that by omitting, it's incorrect. So,
You can agree with the sin of omission rather than commission, you just aren't sure that it makes any difference.
yeah, right.
Okay.
And I'm not either, but.
Okay. And, you know,
Except perhaps as to, I mean, what I was trying to get to was the question that can a prosecutor say something different than the judge? And here it's not like the prosecutor's statements contradicted what the judge said, but they filled in things the judge left out that the judge should have been explaining.
you know, I can see you saying that, and I understand that, but in a way it did contradict because the prosecutor was saying these are equal, and consider both of these before you get to second. The judge didn't say that. The judge said, the judge was much more hierarchical. So I don't think it filled in. I think they do contradict each other because the prosecutor was right and the judge wasn't. You know, it's interesting. I argued, really, I thought about this later, in a misstatement of law violates a defendant's right to due process if it could confuse the jury. And really that's the basis for my reversibility argument here, is that it could have confused the jury. And so I actually, in my brief, offered a harmless error standard of, I believe I offered clearly erroneous. But when I think about this, I really should have been arguing a constitutional harmless error standard, because if we're saying it violates his right to due process, the misstatement of the law in the court's instructions, then it really should be a constitutional harmless error standard. And again, it just goes to the level of certainty that this court has to have as to how much the error contributed to the verdict.
Okay, let me make certain I understand where you're going there.
Okay.
Saying that if the prosecutor had made a misstatement of the law and the judge had said the correct, had recited the correct law, we would be looking at that under the constitutional harmless error standard. And so,
Because it was prosecutorial misconduct rather than.
well, because it was a misstatement of the law, which was error, and you're saying that if the judge makes the error, then it shouldn't be any less of a standard. Is that what you're arguing?
Right, a misstatement of the law either way. But I think,
Regardless of who makes the misstatement of the law, you're saying that the constitutional harmless error standard should apply.
right, because it violates his right to due process because of the jury confusion.
Have we, have we said in cases of prosecutorial misconduct, when there's a misstatement of the law, that it automatically goes to Chapman and not 6261?
What you say in those cases, if there's error, then it's reviewed under both standards, I believe. And error of law is reviewed under both, so. Again, just in terms of the harmlessness standard, it just puts the burden on the state then to show, and we go to the no reasonable possibility instead of the more firmly convinced standard. And again, I think in terms of trying to figure out how this would affect a jury verdict, I just don't, in terms of the significance psychologically of I just think you look at those line of cases like Graham and Cribbs, and I think you have to just, those cases said when the jury was not instructed correctly on how to consider offenses, that it's clearly erroneous because the possibility of a different verdict, you just don't know. I mean, I think jury confusion here can be established, and then it's just a matter of, yes, this could have affected the verdict. I think that kind of segues into my second issue, which is the denial of the accomplice instruction, and that was requested. I think I clearly set forth in my brief why that's error.
Can I ask you about the standard of review here? Because was it clearly requested?
The accomplice instruction?
Do we know who proposed giving it? And then doesn't the judge raise the question of we have to talk about whether this will be given? And defense counsel at one point says, refers back to the first trial and the argument he made there that the accomplice, because the judge pointed out the statement in the PIC about not giving it if there are co-defendants. And in response, defense counsel said something like, I know I argued at the first trial that that statement doesn't apply because they're not co-defendants in the same trial, but then he goes on to say, but I think it's very disingenuous of me to say that. Given that
That's
statement,
interesting.
do we have to apply a clearly erroneous standard? I mean, to me, it seems like the defense counsel argued against the instruction.
That's interesting. I'd have to defer the record. I didn't pick that up from the record. I picked up that he wanted the instruction, and his logic made sense to me about that doesn't apply when they're not in the same trial. But I think the disingenuous may have just been more of a flippant comment, because that goes against the grain of the whole reason they're having the discussion is because defense counsel wanted the instruction. So I'm not quite sure what to make of that, to tell you the truth.
Yeah.
But I think what I wanted to emphasize in this case is that in order for the state to get a conviction here, you had to believe that Gerardo, who was the accomplice, and then there was a third person inside the car. That's the state's case. And the defense in this case is Gerardo's the guy who's actually got the motive to shoot, because he's the one that had the altercation with Leyva at the nightclub. Instead, Dominguez, who is totally new to this scene, he's a co-worker of the friend Manuel Garcia. They're co-workers. Everybody else is in this group, and they all know each other. And so this Mr. Dominguez comes in who doesn't really even know any of these people, and for some reason takes it upon himself to shoot Leyva. And so
I thought there was testimony that the defendant here was chastising Gerardo for not sticking up for himself or not doing something about it. Was, you can't be disrespected like that and let it go. The way I took that is Dominguez injected himself in here to cure the disrespecting that took place in the bar.
All right, fair enough, but Gerardo's the likely suspect there. He's the one that the women are saying this is the guy that did the shooting. So without Gerardo's testimony and the third person in the car, there's no conviction here. That's their case. That's their evidence. I mean, the only other evidence they had is the person that got wounded said it, the guy outside the door had the same clothing as Dominguez, but that's it. So you've got this, I mean, in a juror's mind, are they trying to set this guy up to take the fall here? That's the defense. So, I mean, that accomplice instruction is fairly important. That concludes my comments.
I have a question on the hard 50 sentence issue.
Sure.
In a jurisdiction check internally, we noticed that the notice of appeal did not mention an appeal from the sentence.
It didn't. I'll have to check that and get back to you on rebuttal.
Okay.
Any more questions? Thank you, counsel.
Please support Emir L. Aranda, Assistant Lyon County Attorney on behalf of the State of Kansas appellant. I guess I just wanted to go to issue number 1 on the instructions. I believe that the standard is clear that the court has to look at the instructions as a whole, the record as a whole, when determining whether there is error first. And
How does the record as a whole tell us that the jury was informed that felony murder and first-degree premeditated murder were being charged in the alternative?
the instructions told the jury, albeit they weren't the ideal set of instructions that's recommended by PIC, but they did say that, I believe,
They were instructed as standalone on
Correct.
the elements, and then there were other instructions that certainly make it look like felony murder is a lesser included offense rather than an alternative charge. And then on the verdict form, it certainly didn't say, you know, pick one of the alternative crimes there. It talked about first, second, and felony.
well, I believe the standalone instruction did tell the jury that in the alternative, the defendant is charged with felony murder, and these are the elements. It gave the elements for first degree. The prosecutor in his closing argument did clearly state the law and advised the jury that the state's theory was under, or that the state had charged the defendant under alternate theories, that they could consider and should consider those together at the same time in determining which of the two they believed occurred. The court clearly and did not necessarily infer a specific order that they had to consider on the verdict form. Verdict forms, standard forms in PIC always put not guilty last, and there's no inference that a defendant is not presumed innocent until proven guilty because of the ordering of the form in that regard. The prosecutor clearly argued to the jury that they were to consider the first degree murder under these alternate theories. If they couldn't decide on that, then they could go to the lesser included of second degree. And the instructions as well advised that second degree was a lesser included of first degree murder. And so, and as well, there were no questions from the jury during their deliberations back to the court indicating that they had any kind of confusion with regard to the instructions as given. And the state has set out that the court did not follow the recommended PIC instructions, but the court didn't misstate the law either. The verdict, there was no, we analyzed this under a clear error standard because there was no objection to the instruction, and that based on the evidence that was presented, there was no reasonable possibility that the jury would have rendered a different verdict. There was sufficient evidence in the record to support the conviction for premeditated first-degree murder. The defendant had purchased the gun after the incident at the bar. Gerardo's threats to take care of the victim and that his homeboys would back him up became a big part of this, and several witnesses testified to hearing that. And as was pointed out earlier, there was evidence that the defendant himself injected him into that crowd in that situation that arose out of the bar, and Gerardo's threats, and did chastise him and encouraged him to stick up for himself, and it's kind of the driving force there as far as his intent goes. In addition, there was evidence from Mr. Garcia Velasquez, who was the backseat passenger, and so certainly there was sufficient evidence in the record to support that verdict. As to the accomplice instruction, the state did analyze this, started out analyzing it. If you took Mr. Jurado's testimony at face value, he certainly indicated that he had no knowledge of what was going to go on, that he had this other intent to go to the house to pick up a girlfriend, that he did not know that Mr. Dominguez was going to get out of the vehicle with the gun, and that he drove away from the scene because Mr. Dominguez got back into the vehicle with the gun and demanded that he take off and drive. So he was fearful in that situation. However, the evidence that was presented to the jury was that, and the state recognizes that they heard that he did plead to solicitation to commit a second-degree murder and discharge of the firearm at the dwelling. And so there was an inference that he, because he took responsibility for those offenses, that he was involved in the underlying crime and probably meets the definition of a person who promotes or facilitates the commission of an offense. So should the court have given the accomplice instruction, it obviously would have avoided the issue before the court here today, made things a bunch easier, but would it have changed the outcome of the trial? And the state asserts that there was no reasonable possibility that it would have changed the outcome of the trial. There was sufficient corroborating testimony presented apart from Mr. Jurado's testimony. Mr. Garcia Velasquez testified. He was the backseat passenger. Mr. Rosales, the other individual injured, shot in the leg inside the garage, he testified. And in addition to their corroborating testimony, identifying the defendant as the individual that committed this offense and had the intent to do so, the jury was instructed that they were to determine the weight and credit that was to be given to the testimony of these various witnesses, which included Mr. Jurado. So under this court's previous case law, as I've cited in the brief, those cases have found that under those circumstances that there is no reversible error. And basically that we'd stand on the remainder of our brief.
Did you notice any defect in the notice of appeal?
I did not catch that.
And so was the state prejudiced by the fact that the notice of appeal didn't specifically refer to sentencing being appealed?
Well, I briefed the issue, but I think in light of the lien, we have some issues with the court's imposition of the Part 50 here. We would have to concede that that aggravating factor, the prior conviction, was not presented to a jury for decision beyond a reasonable doubt, but I did not catch the...
So your prejudice is that you have a potentially losing issue.
Well, I think that the remedy is, though, that it's a remand for resentencing in conjunction and in accord with a lien.
Any further presentation for us?
I don't believe so. Thank you.
Any further questions? Thank you, counsel.
Thank you.
Okay, Justice Luker, I went back and looked at that jury conference discussion, and what counsel says, I think what he's talking about is he doesn't think his argument's very good. Because he said, I argued this to you before. And you're right, the court brought this instruction up and says we need to talk about it, and defense counsel says, you know my position, we argued this before. And it's really probably because the PIC book says you don't give the instruction where they're a co-defendant instead of saying where they're a co-defendant in this trial. And so counsel's saying, I made that argument, but I think it's disingenuous of me to say, in other words, it's a weak argument. I made that argument, but, if you read Pick, you're right. We shouldn't give this instruction because he's a co-defendant. So that's how I read it. Not
And
that
so,
he's saying don't.
given that, do you
he's
think we
saying-
apply, which standard do we apply?
Well, he's still requested by the defense. Counsel's just being honest and saying, I don't think I got a very good argument here.
So you,
But
so you would
it's-
still apply the requested instruction?
It's still requested, right?
Even if it's a disingenuous request, it's still a request?
Well, even if it's a foolish one, it's still a request, so. And then I don't have the notice of appeal with me, so I can't really speak to that.
Would you like me to read
No,
kind of the portion of it, just to see if you have a thought, if there's an argument you would make? When it gets to the part that talks about this notice that he intends to appeal, the jury's decision rendered on the 4th day of March 2011, the instruction that the court did not give on a cooperating defendant, as well as the court's decision denying defendant's request for a new trial, which was given on the day of his sentencing, the 2nd day, April 2011, period.
yeah, that is kind of specific. I really just haven't thought about this enough to really speak to it, so
That's fair.
I'll have to check those next time.
It's consistent, isn't it, with what happened at the sentencing itself when the defense counsel said, I'm not going to present any evidence of mitigating circumstances, I'm not going to challenge the aggravating factors because my client's not guilty and we're going to appeal his conviction. And it essentially indicated that they we're going to challenge a sentence.
Yeah, I think that's kind of reading.
Seems consistent with that, then he specifically doesn't appeal the sentence. But
Well, yeah, but I think the counsel's failure to contest the hard 50 actually was kind of shocking to me.
Right.
And so I don't think you can read that means that I'm not going to appeal
Well,
this sentence. I just don't, they just didn't challenge it, but.
I
that
mean, it
doesn't
may be
mean-
ineffective assistance of trial
Right.
counsel, but
Or so, then, for some
but-
reason, I just don't want to appeal a hard 50 sentence.
I'm just saying, it appears to me to be consistent with the position the trial counsel took at the sentencing.
Or you could read it that I'm putting in the notice of appeal specifically what I think the errors were here, what I think the court needs to look at, but that doesn't preclude other things. You could read it that way, too. Sometimes they think they want to point out exactly what was done wrong, so.
But they usually include that magic language in all adverse rulings against my client.
Yes, that's in good language.
Sort of like the continuing objection, it's form over substance.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for the arguments this morning. Court will take this matter under advisement.